this afternoon. Thank you for the opportunity to be here today. I know we missed your last meeting, and apologies for that, but it's simply a matter of timing. If I could, Mr. Chairman, with me today is Rose Rittenhauer, who you probably know is the Deputy of the Civil Litigation Arena in our office, and also Heath Router, who runs the Consumer Counsel Division. My role is that of the Deputy in the Commerce, Environment, and Technology arena, and as a result of that, some of our lawyers in the environmental section had some input in the development of the Attorney General's comments and the development of what it was that we submitted to the EPA on the 111D rule. If I could, I want to tell you a little bit about how we went about the task of looking at this rule when it first came out. What we did internally was to have a working group which included Consumer Counsel, litigation folks, as well as the environmental group. And basically, we entertained and met with a significant number of interest groups, not indifferent than what I think this committee has been doing during the course of your evaluations. Probably a dozen or more groups ranging from incumbent utilities, investor-owned utilities, to obviously conservation organizations and others. So that was the process, and that's what really informed the basis of the comments that we undertook to provide to the EPA. Those comments really had three areas of import, I think. One was to address potential impacts on and implications for consumers. Secondly, to look at some areas that we thought, some of which you all have talked about here today, were areas where EPA should look for improvement on the proposed rule, and finally, a number of legal issues that were raised in our comments. So let me just move to sort of the premise of some of the sort of bulk of our comments, and they were fairly limited, candidly. We assumed, and I think correctly so, that climate change is a real thing, and it does have impacts, and is having impacts both on the environment and health, and not the least of which is environment, infrastructure, and economic growth, probably in the Commonwealth. If you look particularly at the Tidewater region, there are matrix points which indicate that it is among those areas nationally which is the most highly susceptible to climate change from sea level rise and other factors. A second assumption is that there are certainly costs with the implementation of any carbon reduction rule, whether it's the proposed rule or whatever else may come out the other end of the chute as this process matures and goes forward, but there are also costs of not doing anything. So the benefits and the burdens are the usual risk management assessments that everybody has to make when they're going about development and commenting on proposals that have the significant and far-reaching impacts that something like 111D does. And while it is far-ranging and it is applied in its application, it's not indifferent than some things we've seen that cross borders between moving forward on public health and the environment issues and balancing it with economic development issues from a historical perspective. So, and finally, we were cognizant of the fact that it is just that. It is a proposed initiative. It is a proposed rule, and it will go through many iterations, and it will go through many challenges, and it will go through lots of various iterations before it becomes final, and that's not a basis for doing nothing, but it is a fair consideration, I think, when you recognize the reality of the development of implication of rules of this nature and the implications over time. So I think with respect to the impacts on consumers, I've talked about the benefits and burdens. Let me turn for just a second to our comments on that we thought were instructive, assuming they get taken seriously and read with respect to the proposed rule. First of all, and they're not indifferent, I don't think, in most respects from what you've heard from other commenters to a very, very large degree. For instance, we commented fairly specifically, and I thought perhaps strongly, with respect to the absence of credit for the Commonwealth on more recent investments that have been made in carbon-free nuclear energy. And why is it that those investments, both on behalf of consumers and utilities, aren't recognized for the benefits that they've achieved as a result of the nuclear expansion, and we're getting more bang for the buck, if you will, from those facilities. Secondly, we advocated for greater flexibility for the states. This mostly, and it coincides with comments that I think DEQ made, maybe in a little bit different way, but our role, of course, with DEQ as a client agency, we're very cognizant of trying to provide the flexibility and the tools they'll need to match whatever ultimate rule comes down the road that they may have to, with your oversight and so forth, develop and put forward that will have impacts on Virginia individuals and businesses and communities. Thirdly, we made the point that consistency in the application would be important from state to state. In other words, and I think this you all began your discussion as the relative inconsistency that could potentially exist under the proposed rule between, say, a Virginia and a West Virginia. So that point we made as well. And finally, we made some comments relative to building blocks 3 and 4, the renewable and the energy efficiency building blocks, that if there were opportunity to utilize the development of the rule to move forward more toward the kinds of initiatives that are referenced in the state's energy plan that the number of you all have worked pretty hard on over the years, that it ought to be used to that point and involve if it wasn't the law of the land, it certainly should be recognized as the goals and the ambitions of Virginia with respect to the mix of energy that ultimately provides the needs for Virginians and for Virginia businesses. I'm going to stop. We'll be here for questions, but Rhodes going to come up and talk to you about the legal issues, but if you want to stop now and ask questions on what I've said so far, I'm happy to do that as well.
Sure. I don't know if I should ask you this or Rhodes, but is there any consideration by the Attorney General, now that West Virginia has sued, are you all looking at suing on behalf of, down where I live, we're right on West Virginia-Kentucky border, and they've got twice as much emissions as we do. Are y'all looking at suing?
Yeah. I appreciate the question, Delegate Kilgore. I think the direct answer is no. Did we look at it in the development and in the conversations with the various groups that we met with? The answer to that is clearly yes. Did we have conversations with the client agencies about participating in that lawsuit? The answer is yes. I think at the end of the day, our view was that, given the nature of the rule as a proposed rule, and that there was an opportunity to work constructively, or attempt to work constructively, that litigation at this stage was perhaps premature.
There are other questions? Thank you.
No.